sights to see, rolling hills or city streets, ocean to ocean and all in between. It's out there just waiting on you and me. Take it in, we got no plans. Good things come to those who can. Live moment to moment and all in between. It's out there just waiting on you and me. So look alive, 'cause while I was waiting for you, paradise is on the other side of the road. We don't know, taking a long way. You and I were born to roll.
Styles. Okay, have two of you guys discussed? Do you guys want to just, let's take the time to look at trial dates off the record if you're fine? I assume that's what we're doing, so if that's the case.
That's what we're supposed to be doing.
I have Judge Metcalf's calendar, so give me a moment, okay?
We have the victim here. So
Okay.
Sure. Should we set the evidentiary hearing as well? Saying, can we do that as well?
Yeah, absolutely.
It's a little tricky because on one of them, Mr. Myers represents himself. I'm on one, he's on the other. So
Okay,
I
but
think he
your
wants,
advisory on,
correct. But I'm
Okay.
saying is for the purpose of, I think he wants me to do everything on one. He wants to on the other one.
well, at some point, he'll either have an attorney or he won't have an attorney. I don't think he can do.
let's just discuss calendar and we can discuss any other issues, but I mean, what do we think for,
Give me one moment. I'm firing up.
yeah, you're fine.
Did you move me to consolidate it yet? So
No.
we did it early or just?
No,
So it will be one trial then?
It should be, yes. It's going to
Okay.
be consolidated.
except for one.
Okay,
It'll likely be consolidated, but
we're thinking 5 days?
we're not doing the consolidation.
We need 5 days, more, less?
I would set for,
I think 5 because there's going to be especially if Mr. Myers wants to show more of the videos.
Sure. Do you know Judge Metcalf is a Tuesday start? Is that right?
well, I did. It took I try not to call it fully off because they were saying it works better if we do pull it off,
Yes,
but that's not
yeah.
my experience. No, I missed the Surface Pros. The Surface Pros kind of work as well. In the office, I have a bunch of docking, maybe even docking stations. I don't know.
We will have that system designed that has a progression of the responses will be filed by Monday, just so we can get that deadline.
Well, your newest motion's response is not due Monday.
Yeah, 10 days. It's Friday, Saturday, Sunday, Monday.
Well, it'll get done in a timely manner, but that doesn't, none of those issues have to be addressed immediately.
Oh. I would think one of them at least does. Obviously, I mean, if it's dismissed, then it is, then it ends it.
No, none of your motions would cause the entire case to be dismissed. Not a single one of them.
No, but most, if assuming my vagueness.
She's really on it.
I would basically, we're going to appeal that. It would be dismissed.
Yeah, and I don't,
I'm putting all my effort in that motion. That's what I'm saying. I want to get that done before I know to start bringing the trial.
yeah, well, just because you want a motion heard immediately doesn't mean you're entitled to have a motion heard
I
immediately.
don't believe it said. I'm saying there's still deadlines there. With the 10-day
Yes, I will follow any of my deadlines, so you don't have to worry about that. I will take care of myself on that.
Because then that's even an issue like that, maybe special action. That's why I want to make sure quickly, if necessary.
Sorry, I'm almost
No,
there.
you're good.
And then in your pleading, you keep putting that he doesn't have access to the law library, and I already provided you information that.
Yeah, I'm hearing different. Like, I don't know. That's what I mean by Mr. I don't know who's telling the truth. Alright.
Well, we can get you the printouts from the jail and they can show you.
Even that, I mean, he says that he only talked to have his
Fine.
access. He says he didn't know.
Yeah, I know. We're just gonna wait a second.
Like, I don't know who's telling the truth. He tells me what's going on.
Hey, Sally. Sally.
That's what I said.
Well, why don't you reach out to the jail and talk to them? You keep having me reach out to the jail, but you go there.
Yeah, they sell us later. They're giving it to him. He says they're not. Yeah, I don't know. I'm kidding. Honestly, I just want to focus on my confess, which is emotions in this case. This side project should make it hard on me.
Well, I mean, part of your job is not just motions. You have an entire job that involves other things.
Right, you have to prioritize.
Yeah, but I shouldn't be doing your job because you're not doing it.
How you doing, Miss Otto? Good, good. How's everything going?
Okay, I have my calendar
Okay.
up and then we have the victim.
Let's just call the, if you have your calendar ready, is Mr. Myers up? I apologize.
No, he's not.
If not, okay. I'm going to begin and we'll proceed. Good morning, everyone. My name is Scott McDonald. I am not Judge Metcalf, obviously. Judge Metcalf is out this week to make sure that hearings can proceed. I will cover for any sentencing dispositions, things like that. I have no problem, and my assumption will be that I will simply recalendar them for another day. Before I begin, I'll read the victim's rights. It reads as follows. If you're the victim of a crime with a case before this court, you are advised that you have rights of justice and due process under Arizona law that include the right to be treated with fairness, respect, and dignity, to a speedy trial and prompt and final conclusion, to attend court proceedings, to choose whether or not to be interviewed by the defendant or their attorney, to be heard before the court makes decisions on release, plea, scheduling, sentencing, and to receive restitution. If you don't have a copy of your victim's rights, please contact the prosecutor's office. We'll begin with State of Arizona versus Jordan Gray, CR 2024-4724, time set for sentencing. Parties announced.
John Robert Granger on behalf of CES CPB4, Robin Schwartz for the state.
Good morning, Your Honor. Ellie Miller on behalf of Jordan Gray, who's present, out of custody, seated to my left.
Okay. I'm guessing we'll simply reschedule today?
Yes, Judge.
All right. Sometime next week at a minimum, what works for you?
Judge, does the court have the 24th next week available?
It does. It is ordered continuing the sentencing until April 24th at 9 a.m. Again, April 24th at 9 a.m. Sir, we'll see you then. Thank you.
Thank you, Judge.
Van Summer?
That's correct, sir. State of Arizona versus Nicholas Van Summeren, CR 2025-0875. Time set for a case management conference. Parties announced.
John Robert Granger on behalf of CES CPB2, James Dalby for the state.
Victoria Otto for Mr. Van Summeren, who is present out of custody directly to my left, Judge.
Good morning, sir.
Hello.
We have a pretrial conference on May 15th. Have disclosure and plea gone out?
Yes, I have disclosure. I have a plea. I'm just looking to affirm the pretrial conference so I can have some further discussions with Mr. Van Summeren.
Anything else we need to do today?
I don't believe so.
Mr. Van Summeren, your next hearing is on May 15th at 9 a.m. At that time, the court will look to set this case for trial. We'll see you then. Again, court will affirm the May 15th pretrial conference. You have a good day, sir. Thank you. How you doing, Mr. Catone?
Good, Judge. How are you?
Good. What you here on?
Martinez?
State of Arizona versus Adeline Martinez, CR 2024-3670. Time set for sentencing. Parties announced.
John Robert Granger on behalf of CES DB Morgan Mahalik for the state. Senator Paulson on behalf of Ms. Martinez, who is present out of custody, seated to my right. She's being assisted by the court.
Okay. So this might be the one sentencing that I don't, from looking at the plea, there's essentially no discretion from the court. It's 3 years domestic violence conditions of probation. I'm happy to go forward today. I'm happy to continue it, whatever you want, but all right, here's what I'm going to do. If at any point this starts to go sideways, let me know and I'll continue this before Judge Metcalf, okay? All right. Ms. Martinez, could you give me your name and date of birth?
Sí, es marzo 22 del 92 y es Adilene Martínez.
March 22 of 92, Adilene Martinez.
Ms. Martinez, based upon your change of plea from March 17th, 2025, judgment of this court that you're guilty of amended count 1, disorderly conduct, a class 6, undesignated, non-dangerous, non-repetitive offense committed September 15th, 2024 in violation of ARS 13-2904A6 and 13-3601. Court has reviewed the pre-sentence report. Probation's available. Probation must be 3 years. Domestic violence conditions. Let me hear from the state.
Yes, Your Honor, that would be our recommendation. Based on the domestic violence, we think so. We can also set a contact with
Mr. Catone.
Your Honor, we need to ask again for probation. Ms. Martinez has no criminal record. She's very young. Again, this is her first offense. She has small children at home, Your Honor, and one on the way. Actually, that's the victim's child, so we're a little bit concerned about the people contact with they have a child, about to have a child in common. I don't think she's going to be a problem. She's had no problems. She works. She takes care of her children. She has not been a problem before this was just a glitch. And I feel certain that it will not happen again, and she will be a model of probation. Oh, I also want to sorry, that the victim has expressed his reservation with the whole thing, and that he has no physical or emotional.
Correct. I believe he requests dismissal. So here's what I'm going to put is there would be no unconsented contact between Ms. Martinez and the listed victim, and the defendant and victim may have contact unless victim or adult probation department revokes. Okay? So that essentially the default will be that Ms. Martinez may have contact with the victim given that they are expecting a child on the way. Ms. Martinez, you have the right to address this court. Is there anything you wish to tell me? Ms. Martinez, I'm going to go through some things with you. You'll have the right to challenge my decision. You have 90 days to file something. Court would give you an attorney and transcript, and if you don't file anything within 90 days, you lose the right to do so. To my knowledge, there's no restitution, and this is your first felony. Assuming that are both correct, your civil rights, things like voting, owning a gun, they will automatically be restored at the end of this case. I'll give you some information on that, as well as how to have your criminal record sealed. There are going to be fines and fees, a $20 time payment fee, $65 probation fees, $20 probation assessment, $13 crime penalty assessment, $2 victim rights enforcement, and $9 victim rights fund assessment, a $50 family offense assessment, and $50 address confidentiality program. Court finds mitigating factors: lack of criminal history, acceptance of responsibility. Court finds no, and I'm not sure it's an aggravating factor, or it's a mitigating factor, but the victim's position. It is a factor the court considers in sentencing. Judgment of this court that it will suspend the imposition of sentence, place Ms. Martinez on 3 years domestic violence conditions of probation effective today. Ms. Martinez, you have to go over to probation. They are 2 doors down from here, okay? So I think I'm putting in the right, actually I think it's that way. Make sure you go over there today, okay? Just to start off on the right foot, you're already down here. Any questions?
No, that's fine.
Okay, good luck.
Thank you.
I've got some paperwork, so just hang tight, all right? Thank you. What is it? Thank you. Good morning. Who just joined us?
Woodrow Jones?
Okay, good morning, Mr. Jones. Give me a moment, okay?
Yes, sir.
State of Arizona versus Militia Stinnett, CR 2025-0097. Time set for sentencing. Parties announced.
John Robert Granger on behalf of CESDV, Morgan Mahalik for the state.
Yeah, good morning, Your Honor. Eric Madge here for Militia and Stinnett is present, out of custody, seated right next to the judge. It looks like Judge Metcalf's out, so we just asked to reset this out a couple weeks when Judge Metcalf is back.
Okay. With that, let me hear, you said how many weeks out? I mean, we can go as soon as next week. There's a listed victim, so we need 5 days, so.
The victim.
Oh, okay.
Mr. Davis is in the back row. So
Okay, good morning, Mr. Davis.
he has notice.
It would have to be next week.
Next week is good.
So,
Can we do, is it the 22nd?
sure.
Good.
It is ordered resetting sentencing until April 22nd before Judge Metcalf, Division 16. Anything else?
That's all, Judge.
All right,
very
thank
much.
you. We'll see you then. State of Arizona versus Letitia Lux, CR 2025-0854. Time set for case management. Parties announced.
John Robert Granger on behalf of CESMCB, Matthew Taylor for the state.
Morning, John Repovich on behalf of Letitia Lux, present out of custody.
Good morning. We have a pretrial conference on May 15th.
We just need to affirm that date.
Okay. Anything else we need to discuss from your perspective?
No.
From the states?
No, Your Honor.
Ms. Lux, your next hearing is on May 15th at 9 a.m. I'll affirm that. You have a good day, okay? Thank you.
Judge, I'm sorry, you said the 5th and then the 15th.
Sorry, it's the 15th, May 15th. Thank you. Sorry, my apologies.
Thank you, Judge.
Okay. All right. Which one? Well, there's only one that's gone, and that was Martinez, right? Sally, if you see Mr. Hill, just let him know that his client's online, all right, or on the phone. How you doing, Mr. Mosley? Sure, take your time. Yes. I saw Mr. Messmer. I haven't seen Mr. Ryan, Mr. Coppin. Who knows? All right. Believe me, I see it. All right. Yeah, that's the only case that she's here for, so I don't want her to wait. Yeah, so I don't want her to wait until she's got other things to do, so. Sure. Good morning, sir. Ms. Stiles, you start trial again next week, right?
Yes.
All right. Yeah, it's making me kind of download. I don't know. How you doing, Mr. Messmer? Sure. Let me know when you're ready. State of Arizona versus Hector Zumano III, CR 2024-3446, time set for a status conference. Parties announced. Morning, sir. We'll need to set a pre-trial conference unless there's some resolution today. So with that, you tell me what you think is reasonable. Sure. Does that work with the state? That would put us to May 6th if my math is accurate. Does that work, Mr. Messmer? Ordered resetting or committee setting a pre-trial conference on May 6th, Division 16. Again, May 6th, 9 a.m., Division 16. Anything else? All right, sir, your next hearing will be on May 6th with Judge Metcalf. At that time, he'll look to set this case for trial if there's no resolution, okay? All right, you have a good day. Okay, can you, yeah.
Go ahead and have a seat, my friend.
Mr. Campo, you ready?
As soon as I get signatures, Judge, I am
Sounds
ready on
good.
Mr. Alejandres.
Yes, sir. How you doing, Mr. Alejandres?
I'm okay. How about yourself?
Doing well.
Is that your mom? What's that, Judge?
She ran over the phone.
It's a strong ringtone, sir.
It will not turn out.
No.
Oh my goodness, okay.
How you doing, Mr. Hill? Mr. Hill, your client's
Right.
ready. Do you know what you're going to be doing on the?
I do, Judge. Where's TV?
All right. Mr. Campo, do you mind if Mr.
No,
Hill
please-
scoots in?
please
How you
do,
doing, Mr.
Judge.
Gibson?
Good, Judge.
You're like a ninja. You somehow you snuck in. I didn't even see you. All right, Mr. Hill, we'll do yours because I know Mr. Jones. Mr. Jones, can you hear me?
Yes, sir, I can.
All right. State of Arizona versus Woodrow Jones Jr., CR 2022-4841, 2024-2536, and 2025-1239. Time set for, it's set as a status conference. I think 2025-1239 should be set as a pre-trial conference. Parties announced.
John Venture, on behalf of CS MCB Matthew Taylor in the 1239 matter, and CS CPB 1
Good morning, Honor. Trevor Hill on behalf of Mr. Jones, who's present out of custody by telephone.
And Mr. Hill, how are we going to proceed today?
Judge, what had happened at the last hearing is we had done an emergency motion to modify. Mr. Jones had a persistent injury to his foot that was getting infected and going to cause him some serious distress. Judge Metcalf let him out, but then set this short set status conference to make sure what the status of the medical intervention was. Mr. Jones had had the toe amputated along with part of his foot due to the issues that occurred. So what I'd like to do is just reset these matters. Mr. Jones has been ordered to remain effectively on bed rest to help deal with the infection and recover from the surgery for about 6 weeks. So, Judge, if we can come back in approximately a month, I think that'll give us a better idea of where he's at his healing journey.
There's a April 29th status conference. Can I vacate that?
I think that'd be just fine, Judge.
Any objection from the state? It is ordered vacating any hearing set on April 29th in any of the matters, ordered resetting the matter. Mr. Jones, I'm going to set this, so your next hearing will be in about 1 month. Mr. Hill, you willing to waive time?
Yes, Judge.
With time waived, looking at the schedule would be May 16th, May 19th.
Either of those dates should work for me, Judge.
Mr. Jones, so either of those dates work for you?
Yes, I'll be on bed rest still, so that should work out just fine for me.
All right. It is ordered setting a status conference in the 2022-4841 and 2024-2536 on May 16th and setting a pre-trial conference in 2025-1239 on May 16th at 9 a.m. Mr. Hill, do you know, sounds like Mr. Jones will be appearing remotely. Is that correct?
That'll be the plan, Judge.
All right. Ordered that Mr. Jones has permission to appear remotely at that next hearing. Thank you.
Thank you, Your Honor.
May 16th at 9 a.m. Thank you. All right. State of Arizona versus, don't spoil it, Mr. Campley. Jose Alejandres Jr., CR 2025-1074. Parties announce.
And Nikki DeCampi, Mr. Alejandros, who's present out of custody, Your Honor.
All right. Good morning, sir. I'm going to go through this. I have a copy of a plea. All right. As I go through this, you have questions, you need time, you change your mind. My feelings won't be hurt. You just let me know, okay?
Yes, sir.
Could you give me your name and date of birth?
Jose Alejandres, 10277.
Sir, do you read and understand English?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
On this plea, there's a signature on page 5 above your name dated tomorrow. It should be the 15th. Is that your signature?
I'm sorry.
Yeah, no, it's okay. Is that your signature?
Oh, yes, sir.
And did you sign that today?
Yes, I did.
I'm going to write in the 15th, okay? And put my initials.
Apologize.
Oh, it's okay. The month is flying, so not a problem. Mr. Alejandros, before signing this, were you able to go through this with your attorney? And was she able to answer your questions?
Everyone.
All right, so let me talk to you about this, okay? This says that you would admit amended count 1, attempted aggravated assault with a deadly weapon or dangerous instrument, domestic violence, a class 4 felony. Is that your understanding?
Yes, sir.
So for consequences, they are as follows. The court could sentence you to prison 1 to 3.75 years. If you're sentenced to prison, you have to serve 85% of that sentence, and for every 7 days in prison, at the end, you would have 1 day of community supervision. That's like parole, okay?
Yes, sir.
The other thing the court could do is suspend sentence, place you on probation for up to 4 years. As a condition of probation, you would have to comply with certain terms and conditions. Additionally, the court could impose up to a year in jail. So the court can impose conditions, things like can't get in trouble, got to check in any classes, treatment, things like that. If you violated probation, then at that point you would come back here, and at that point that prison sentence is back on the table. You do well on probation, then ultimately probation period ends and the case goes away, okay? It's kind of a way that that sentence would hang over your head. All right? Finally, there may be fines and fees that may go up to $150,000 plus a 78% surcharge. And if there were any damages to the victim, you may owe them money. So again, consequences are 1 to 3.75 years in the Department of Corrections, fines and fees, up to 4 years probation, and possibly damages to the victim. Do you understand those possible consequences?
Yes, sir.
Do you understand that having a felony on your record can have other possible consequences on your life?
Yes, sir.
Do you understand that having a felony can impact your right to vote, to hold a public office, to serve as a juror, and to own a gun?
Yes, sir.
Did anyone promise you anything different or better than what we just discussed?
No.
Anyone force or threaten you to enter into the plea?
No, sir.
Do you understand that if you are not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status? Admitting guilt may result in deportation or removal, even if the charge is later dismissed. Your plea or admission of guilt could result in deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. Do you understand that?
Yes, sir.
Are you on probation or parole for anything else? I apologize if I asked you that. Let me talk to you about your rights, sir. To my knowledge, there's no trial. Is that right?
No.
So there's no trial, okay? But if you wished, you have the right to set this case for trial. At that trial, you're presumed to be innocent. It will be a jury trial. You would remain innocent until the state has proven that you are guilty by proof beyond a reasonable doubt. You would be represented by an attorney at little or no cost if you cannot afford one. She would be able to question anyone who testifies against you. She can make witnesses come in here and testify on your behalf, even if they don't want to be here, through a subpoena. If you wanted to testify, you could. If you decided you didn't want to, that fact would not be held against you. All right? This is all what kind of trial would look like. Additionally, ordinarily with trial, you have the right to file a direct appeal to the Arizona Court of Appeals. Okay? By going forward with this, you're giving up that right to file an immediate appeal to the Court of Appeals. Instead, you have to file something first with this court. Do you understand that today there'd be no trial, no direct appeal? Instead, I'd find you guilty based on what Mr. Campley tells you?
Yes, sir.
Okay. And knowing all that, are you okay going forward?
Yes, sir.
And you understand once I accept it, essentially, you're kind of stuck with it?
Yeah, yes.
Okay. As to amended count 1, attempt with a deadly weapon or dangerous instrument, domestic violence, a class 4 felony, how do you plead? Guilty or not guilty? Counsel?
Thank you. On January 1st, 2025 through January 31st, 2025, Mr. Alejandres and his wife, Raquel Rodriguez, were involved in ongoing arguments. At one point during that period of time, he raised a weapon and she was put to strike with it.
Okay. Sir, you heard your attorney is what she said, true and correct?
Yes, sir.
And just so not sure I said it, but do you understand that your, whatever the gun was may be forfeited, meaning you're not getting it back?
It's in the special terms,
Okay,
Your Honor.
yeah. All right. Subject to incorporation, state satisfied?
Yes, Your Honor.
Court finds defendant's plea is knowing, intelligent, and voluntary, supported by factual basis. Court will accept the plea. Court finds, and court will order a pre-sentence report be prepared. We'll set sentencing, and court will order a pre-sentence report be prepared. Mr. Campley, what are you thinking?
Your Honor,
Sure. And what's her name? Or Ms. Rodriguez, are you there? Ms. Rodriguez? Ms. Rodriguez, if you are there, I'm going to schedule sentencing. If you something does not work or wish to be heard, let me know. Thank you.
Is Thursday, May 15th, okay for you? Yeah. Judge, we actually have a pretrial on May 15th, and we can just turn that to a sentencing.
Sure.
And I don't think I said this occurred in Pima County.
Okay. And you agree this occurred in Pima County?
Yes, yes.
Okay. Court will vacate the pretrial conference on May 15th, and the court will set a sentencing on May 15th before Division 16, Judge Metcalf. Anything else?
No, sir, thank you.
All right, thank you. Mr. Gibson, you ready?
Yes. That's it.
Take that.
Which case?
Lopez.
State of Arizona versus Christopher Lopez, CR 2025-1075, time set for case management. Parties announced.
John, I have a claim on behalf of CSCV Market House for the state.
Brian Gibson, got Christopher Lopez, who's president and trustee right here to the right.
Good morning, Mr. Lopez. Time set for case management. We have a May 15th pretrial conference. Anything we need to discuss?
No, Your Honor, I confirm that pretrial conference date, and we have received disclosure. There's a pre-offer available right now.
Okay. So is ordered affirming the May 15th pretrial conference. Mr. Lopez, your next hearing, unless something happens, will be May 15th. At that time, the court will look to set this case for trial if there's no plea. Anything else?
That's all I have, Judge.
All right. Thank you. Good to see you, Mr. Gibson. State of Arizona versus David Camarillo, CR 2025-0441. Time set for pre-trial. Donald and change of plea. Parties announced.
John, I have a claim on behalf of CSSVU, Haley Lygos for the state.
Kurt Mosley on behalf of Mr. Camarillo, present out of custody to my left. Permission to approach, Your Honor, so I
Sure.
to enter a plea.
Sir, I'm going to go through this plea with you. Could you give me your name and date of birth?
State Andrew Camarillo, Jr., 8/14/85.
Sir, do you read and understand English?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
Yes, sir.
There is a signature on page 5 above your name dated today. Is that your signature? Before signing this, were you and Mr. Mosley able to review it together?
Yes, sir.
Was he able to answer your questions? This says that you would admit count 1, failure to register as a sex offender, a class 4 felony. Is that your understanding of the plea? So let me talk to you about consequences. They are as follows. The court could sentence you to prison, 1 to 3.75 years. If you were sentenced to prison, you have to serve 85% of that sentence, and for every 7 days in prison, you would have 1 day of community supervision. The other thing the court could do is suspend sentence, place you on probation for up to 4 years. If you were placed on probation, the minimum term would be 3 years, so it would have to be 3 years, and it could be up to 4-year probation. They would be special conditions of probation. Those conditions were attached to the back of your plea, all right? They are more restrictive. It's more difficult probation, all right? The way probation works is this, is that 1 to 3.75 years kind of hangs over your head. If you do well, then this case goes away. If you violate probation, then at that point you would come back here and that prison sentence is back on the table. Additionally, as a consequence of probation, the court can order that you serve up to a year in jail. Finally, there may be fines and fees of up to $150,000 plus a 78% surcharge. Do you understand all those possible consequences?
Yes, sir.
Do you understand that having a felony on your record can impact things like voting, owning a gun, serving as a juror, holding public office?
Yes, sir.
Do you understand that having a felony on your record can have other consequences on your life? Did anyone promise you anything different or better than what we just discussed today?
No, sir.
Anyone force or threaten you to enter into the plea?
No, sir.
Are you on probation or parole for anything else at this time?
No, sir.
Let me just make sure you understand, sir, that if you are not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation, even if the charge is later dismissed. Your plea or admission of guilt could result in deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. Do you understand those possible consequences? And let me talk to you about your rights, sir. If you wished, to my knowledge, there is no trial set, okay? So if you wish, we would set this case for trial. It would be a jury trial. You'd be represented by an attorney at little or no cost at that trial. It would be a jury trial. You would be presumed to be innocent. You would remain innocent until the state has proven by proof beyond reasonable doubt that you are guilty. At that trial, your attorney could question anyone who testifies against you. He could make witnesses come in here and testify on your behalf, even if they don't want to be here. You're a subpoena. If you want to testify, you could. If you chose not to, that fact would not be held against you. You'd be given up your right to have a jury find aggravating factors. That's how your sentence would go above the 2.5 years up to 3.75 years. And finally, you'd be given up your right to file a direct appeal to the Arizona Court of Appeals. That means that if you did not like something, your only option is to first file something with this court. Do you understand that today you'd be given up all those rights, there would be no trial, and the court would find you guilty based on what Mr. Mosley tells me?
Yes, sir.
All right. Knowing all that, is that how you wish to proceed? Do you understand once I accept your plea that essentially you're stuck with it?
Yes, sir.
All right. As to count 1, failure to register, a class 4 felony, how do you plead? Guilty or not guilty?
Yes, sir.
Do you agree that on or between January 1st, 2024 through January 20th, 2025, that you were required to register as required by ARS 13-3821, and that you did not register?
Yes, sir.
Okay. State satisfied?
Yes,
And that was here in Pima County? Okay. Court will find that there is a factual basis. Court will incorporate the grand jury transcript. Court finds defendant's plea is knowing, intelligent, and voluntary, supported by a factual basis. Court will accept the plea. Court will order a pre-sentence report be prepared. We'll set sentencing approximately 30 days out. Mr. Mosley, what works for you and your client?
30 days approximately, just on a Monday, Tuesday, or Wednesday.
Sure. May 19th, is that okay?
It's a Monday.
Yeah, let me just make sure there was a day I'm supposed to avoid, and it's not that day.
Yeah.
That will work, Your Honor.
Okay. Ordered sentencing on May 19th at 9 a.m. Sir, let me just tell you, between now and then, probation is going to do a report. That report helps me to understand whether or not you're a good fit for probation. So get that report done, okay? We'll see you then. You have a good day.
Thank you, Your Honor.
Thank you. Who's on the phone? Is there anyone on the phone? If so, just speak up, okay? Thank you. Morning, sir. Counsel, just let me know when you're ready. You ready?
You need the mic.
Yeah.
Oh, we did, yeah. The journey. He's gonna need to sit there, Mike.
No, you can just move.
Just move it, yeah. State of Arizona versus Lane Myers, CR 2025-1060 and 2025-1454. Parties announce.
Rachel Stiles for the state, and Your Honor, the victim is present in the courtroom.
William Parvin on the second case number, I think it ends in 1454. I represent Mr. Myers who's in custody, and Mr. Myers, you announce your appearance for the first case number where you represent yourself.
John William Myers.
Okay, and serving as counsel from representing himself in 1060. Mr. Myers, my name is Scott McDonald. I am covering this hearing for Judge Metcalf. I assume we're here to set trial and any other hearings that need to be set. So with that, what are the parties thinking?
Your Honor, for trial setting, we're looking at July 21st. That works with the victim. It sounds like that works for Mr. Parvin's schedule. That works for my schedule. So that's when we'd like to set it for 5 days.
Let me just make sure that works.
July 21st, right?
It does. All right.
Do I get any say in that?
You represent yourself in 1060, so yes, sir.
That doesn't work for me.
Okay. What are you proposing, sir?
Next week.
So
How about 30 days from now?
We've got to hear this motion first to dismiss the case.
All right, so like 25 days from now. So that 35 days, because that'll give me 20 days before trial. and
Mr. Myers, let me just ask you, because the state is trying to have these two cases, they're going to be consolidated. Is that,
We're going to put in a motion. I want to make sure that Mr. Myers has time to look at that, and that way if he has any objection to it once he looks into it. So that'll be addressed at a different time.
Talking about the motion to consolidate?
so one moment at a time, okay?
So right now, we can just set the 1060 trial, and then if the other one's consolidated into it, then that'll be at the same time. And that is within the speedy trial time. The speedy trial time's not till August. This is the case management conference.
Okay.
Judge Metcalf just also accelerated the pretrial conference so we could set trial right away.
We're sitting on both, aren't we? Because I'm ready to set it for trial the same date on the one I'm still representing him on.
They're not consolidated yet, so we can't set them yet. But if they get consolidated, then they will happen at the same time.
As long as we're not waiving any
Can
rule.
you set another pretrial?
Hold on, we'll get to that.
Hold on, Mr. Myers. One at a time, okay? So let me just kind of understand. So Mr. Myers is asking to set trial sooner than the July, I apologize, 21st date. Do you have any availability? I know you were in trial, I believe the next 2 weeks. So do you have availability sooner? And I'm going to go through. So looking at that would be about, let me ask Mr. Parvin, giving your motion, what do you think a reasonable time frame to hear that?
On the other case.
No, Your Honor, may I explain? This is a
Sure.
little tricky. Mr. Myers wants to represent himself on one case and has his ideas and certain motions. Because he picked up a second case, he was non-bondable. At least as of now, I'm working on that. I was assigned the second case, and there has not yet been a Ferretta motion where Mr. Myers can choose to represent himself. That's a silver lining because it allowed me time to file motions I think are appropriate. And I talked to Mr. Myers about that. I filed a very strong motion to dismiss on vagueness and challenging the statute that's never been challenged before under the new law. I would like that to be heard. I believe it may be dispositive where there may not be a trial, or if there is, it'd be on a lot less charges. That needs to be heard first. Now, I know Mr. Myers wants a trial, but I strongly recommend he join in my motion and that we hear that first. And the July trial date is still within the 150-day time period. It's not violating any speedy trial rights. It works for my schedule, works for apparently the state schedule. That means if it turns out it doesn't work for the state schedule, the case is going to get dismissed because your rule 8 would be violated. So they're validating they're ready to be ready that day. They better be ready.
So,
But the point is that right now they're not consolidated. I'm sitting in jail with no bond.
Okay.
I don't have access to any way to prepare for my case. So sitting in jail is a complete waste of time because I'm going to get a new trial for not being able to prepare for my case. So the faster we have this trial, faster we can have the next trial and the next trial and the next trial and the next trial. Now, so it's actually worse for the state to have it. The longer I sit in jail, that's more arguments for me to not have be able to effective. So all they're doing is creating more prejudice against me the longer I sit there. So the faster we have the trial, the less that we get through the first wasted time trial and get to the second trial, maybe third trial, fourth trial, however many trials we need to have, where I can effectively represent myself and put forth a case, because the Court of Appeals is going to throw out any convictions that are in this trial because I have access to no material. They've committed Brady violations and they perjured themselves under the grand jury. And so, yes, I need a little bit of time to file the 12.9. I realize that'll stop the time for a few, but it is also probably going to get the case dismissed because they lied to the grand jury. And now I'm going to file a Brady motion, and I'm going to file actually a Rule 16 motion to dismiss. I'm going to file to dismiss, or in the alternative to remand under 12.9 for their failing to provide exculpatory evidence and the detective perjuring himself and the grand jury. And then I'm going to file another motion to dismiss because they're violating under State versus Warner, because they're violating attorney-client privilege, and I have no way to have a privileged communication in the jail. They've invaded my work product, and I want to. So you're gonna have to set a hearing on the Warner motion, because under the state, it requires an evidentiary hearing for me to be able to prove the prejudice when I have them literally within an hour of me having a communication with my lawyer. They're doing things to counter my argument. So I've already effectively caught them in a trap of violating attorney-client privilege, violating work product, and I'm not getting a fair trial. So as soon as I file that motion, there's going to need to be an evidentiary. So there's going to be 3 possible reasons to have it dismissed, or it's either going to be dismissed under 12.9 or remanded. 16, it's going to be dismissed for it's insufficient as a matter of law. And on the State versus Warner, the holdings are the controlling case law in State versus Warner is going to say that you have to set an evidentiary hearing, and then that shifts the burden to the state to prove that they weren't violating my thing when I got it all right here to prove that they've went through my work. I have no way of effectively preparing a case in custody because they know everything I'm talking about. They know everything that I want, any case law I want, any communications that I say, hey, help me get this legal document. First of all, how am I going to get work product off my computer at home? How am I going to get my disclosure that I'm required? So I'm going to be in violation of Rule 15.2 because I can't even give them the disclosure that I want to give them because it's at home on my computer. So I have no way of getting it. And if I call
Mr. Byers, do you mind slowing down? Ellen here is taking down
problem.
everything. Thank you.
So if I try to contact people outside of the jail, either through the text on the tablet or by phone, to say, hey, I need this or I need that to prepare my case. Well, they're listening, and I've already caught them in 3 traps listening to my work product. And I'm telling you, under State versus Warner, the burden is going to shift to them. They're not going to be able to do it, and the case is going to have to be dismissed because I'm suffering extreme prejudice because I cannot prepare a defense if they know everything I'm going to say at trial before I say it. That's not that's you're supposed to represent. You're supposed to preside over a fair trial. Well, there's anything but fair going on here. They're literally invading my work product, and so under State versus Warner, it's clear all the way up to the 9th Circuit. The case is going to have to be dismissed, and if it isn't, the circuit court or the Court of Appeals is going to dismiss it because there's no way they can say they didn't invade my work product when I got them caught red-handed right here in front of me. And that's what I was supposed to discuss today, so that I don't know how you're saying set other hearings. Well, I'm going to need an evidentiary hearing on the Warner motion. I'm going to need I don't know if they do an evidentiary hearing for the 12.9, but they probably would because it's going to be a motion to dismiss. Because I was denied a substantial procedural right of having the fair and impartial evidence and exculpatory evidence being presented to the grand jury. So that's actually dismissal reasons and in the alternative remand. And then on top of that, I'm going to file the Rule 16. So I don't know if he's going to want to have a hearing on the Rule 16 motion to dismiss as insufficient as a matter of law. But all that stuff, I only need to file that 20 days before trial. So sitting in jail, waiting till July is a complete waste of time. I'm suffering extreme prejudice. There's no way I can sit in jail and prepare my case when they're listening to everything I'm doing. And furthermore, they're going to be able to hold it against me that I didn't give them their disclosure. So it's not even ever going to be a fair trial because I have no way of getting my evidence from my house to the court. I have no way of getting my Rule 15, the disclosure, the exculpatory evidence I want to present. I have no way of contacting witnesses from jail. What am I going to do? Contact my witnesses and have them come to the jail? The jail's just going to let random people come in the jail and let me interview them? No. The jail's already denying me the law library. They said they don't care what the judge says. The judge doesn't control the jail. Rachel promised the judge that she was going to make sure that I got access to the law library. And let me see here. So is this everything? Rachel, where's my witness list that was due yesterday? Rule 15 disclosure was due yesterday. They've failed to meet their obligation. I already had a motion to compel. Judge Metcalf said we had to wait for the 30 days. The 30 days expired yesterday. I don't see the Rule 15 disclosure in front of me. You got it? Did they give you the witness list?
So,
A lot of disclosure. I don't think I have a witness.
Well,
list
the witness
yet,
list was
but-
due yesterday, so now I'm going to move to exclude anybody on their witness list as a sanction because it was due yesterday.
Okay.
And the judge made it very clear, Rachel, or Ms. Stiles, that you must provide the disclosure even if it's in jail. We don't want to hear the excuse about you gave it to Parvin. I see people get mail from the Pima County Attorney's Office every single day in jail. They haven't given me the rule. Where's the witness list? It was due yesterday. So if
Mr.
I don't
Myers-
have the witness list, they're in violation.
So just
Did they give it to you?
I don't think.
So exactly.
Mr. Myers, one quick
That's
thing,
updated.
or a couple things, okay?
Yep.
So one, you said that the 12-9 motion, I can't give you legal advice, but
I don't-
hold on, that has to be filed sooner.
No,
than
no,
the
we
20
already got
days.
an extension on that.
Okay.
I got
good.
it. Yeah, I already
All right.
asked. I immediately asked
Okay.
for an extension out to 60 days, and I'm gonna ask for that
Right.
in the. I want the I
He-
want the case that because I'm gonna be once his motions are heard, then I'm gonna take over pro se, and I
So-
want that extended on that too.
Mr. Myers, here's what I'm gonna do. If you need to file 3 motions, okay?
I have no way of doing it at the jail, so
and
I'm putting it
get
on
an
the record.
evidentiary hearing, it's not enough time to set it in May, okay? I'm happy to look at May dates, but
Okay,
I'm
early
telling
June?
you. So I'm happy to look at, if.
They got to convict. They got to
May I
convince
respond?
12 people
Sure.
unanimously. to
One
convict
person
me.
at a time, please, for Ellen's sake, okay?
Yeah, I feel you.
All right, so Mr. Myers, I'm gonna hear from Mr. Parvin, then Ms. Meyer, or to me, Ms.
I got a
Stiles.
lot of stuff though,
I
still
know.
points of
I-
order for the pretrial. Like we're supposed to be discussing disclosure. I got some other things to put on the record here. That's
And-
happening.
Mr. Myers, I'm not your judge. I'm here just to set dates. If you want to just simply
It's
come
not, but
back.
the judge told me today I would be able to, he told me to come back and have, it's supposed to be a case management conference. It's supposed to be more than just setting dates. It's supposed to be me making,
Mr. Myers, let me
putting
talk.
stuff on the record, asking the judge to order things. So so you can't order things?
I am not your judge. I'm not familiar with your
Doing today.
case.
Let me Myers, let me talk a little bit.
Yes.
I've been in communication with Judge Metcalf's clerk and Ms. Stiles. We've arranged to have a Monday hearing at 4 o'clock, hopefully earlier if the restitution hearing that's going on is done sooner. That's going to be a bond rehearing motion that I filed notice of that. And all these issues that Mr. Myers brought up, I will address as his attorney of record on that case, although Mr. Myers, I believe, can have input if I don't know if both cases are heard that day or not. I suggest that the court order both case numbers set on that day. We can address then any hearings that need for evidentiary hearings or Mr. Myers' concerns. I also feel I need to clarify for the record, the jail has never stopped me from going, unless there's a lockdown, which happens more often than it should. Generally, I can go there and talk to Mr. Myers in person. I've spent hours, sometimes an hour and a half, sometimes 2 hours, talking about motions and evidence with him in the jail privately. That's not recorded or anything like that. The issue
That's in
is,
that case.
again, or several, okay, okay.
That's in that case.
On my
not in this
case, yes. The one I'm appointed on, I'm not just
1454.
advisory.
Yeah, right.
Yes.
Not my
There's
case.
been no issues. The issue is, since Mr. Myers is acting as his own attorney, he needs to, I guess, prepare defense. And since I'm not always available to spend hours at the jail in person, he needs to text other people or arrange to work on his case, and that's monitored on a daily basis. That's his problem.
Okay.
Again, I'm going to address that on Monday, and I think there are suppression motions that I could file on my end to deal with that, his concerns. But I'm just making known to the court there hasn't been a problem stopping privileged communications. That's never been a problem.
I disagree.
And
Okay.
Can I just, I'm going to ask Mr. Parvin one question, and then I'll hear from Ms. Stiles. Mr. Parvin, from your perspective, I'm happy to simply continue the pre-trial conference until Monday. I'm happy to set trial on July 21st, and if you want to accelerate it, whatever you want. So again, I am just filling in today. I apologize.
Well, I think for my, again, we're
He's sitting in jail
within
tomorrow.
150 days, and if I'm going to be doing the trial, I would like that July 21st.
He's not gonna be
date.
doing the
That
trial.
gives me time to prepare on my end. I want to do a good job, and I want my motion dismissed heard. I believe it has a lot of merits. That's my concern. Mr. Myers, I need you to join in that motion. Can you
I will.
please do that?
I will.
Can you orally do that today?
Oh,
Or you
yeah.
can join in my motion?
But I'm saying,
Has it
as
been
soon as
filed?
his motion,
Yes,
yeah,
it's been filed. I just need him to join on his, so therefore we can hear it on both case numbers.
you're talking about
My motion is dismissed. I just handed
right,
you.
the one. So
The
it's going to
harassment.
apply to both case
It
numbers.
should, as long as you join in it.
Right. Okay. So I want to join that, and what I'm saying is all the motions got to be filed 20 days before trial, right? So my thing with Mr. Parvin is that once we hear his motions, and once the state argues to keep me in jail with no bond, it's all gas, no brakes. And so we don't need to waste taxpayer dollars, the court's time, the people's time, holding me in jail, wasting my time when I can't even prepare for the case. The faster we get to the case, the faster we get to the next trial, the next trial, the next trial. And so to me, what do we need to wait for July for? Nothing's going to change. The state has 30 days to give me they haven't even given me the evidence. What's going to change? They haven't done their diligence in this case yet. I've known these people for 9 months. I know how they work. I've had a judge give them 3 orders to give me disclosure, and they ignored it. And then they wait, and then on the 180th day, they dismiss the case. And so I'm not playing games. I'm sitting in jail with no bond for no crimes, and I don't have a way to prepare for the case. So you can't sit here and say that I'll be sitting in jail getting a fair chance to prepare for a trial and have a fair and impartial trial, because I'm extremely prejudiced being in jail, right? And so my thing is what does July do? It just lets them sit there and try to make me sweat, and then they're going to try to offer me some stupid plea bargain, and I'm going to laugh at them. And so
It guarantees you a
do you
trial
want me to
date.
set a
Here's the
hearing on
thing.
the motion to dismiss today?
Your Honor,
Can you do that?
he's saying that he wants.
Have your-
Hold on. Yes.
I wanted to
Mr.
clarify
Myers?
something about the trial. He said that in July it works for him.
Yes.
He's not going to be my lawyer for trial.
Understood.
Okay.
Thank you. Ms. Stiles.
Your Honor, in regards to the law library, the jail essentially, they took where it was, the law library was a place they went to. Now it's all electronic. It's on his tablet.
I don't have a tablet. That's incorrect.
He does. And so what happens is I've confirmed with the jail, there's 1 tablet per 2 inmates. The same tablet he uses to do all his phone calls, his video visits, that is the same tablet that he has access to LexisNexis. The jail has a contract with LexisNexis that gives every inmate free access to LexisNexis. LexisNexis is, the competitor to Westlaw, so he has access to all the same things he would have had through Westlaw because he's familiar with Westlaw. He has been accessing that since March 21st. So we've been able to verify with the jail that he has been accessing the legal resources that are essentially the law library through his tablet, and has been consistently since March 21st. Also, they have confirmed for me that, and I've filed a notice of this, they've confirmed for me that if he has any research that he finds on there that he wants printed, he just puts in a request with the law librarian and it'll be printed for him. That if he doesn't have pencils or paper and can't afford to buy it from commissary, that he just fills out a slip to say he's indigent, and then that will be provided to him. So the case law just requires for him to represent himself that he has access to the legal resources or that he has advisory counsel. In this case, he has both. So Mr. Parvin is law trained, and so he is able to also assist Mr. Myers with any research that he wants done. He's able to assist him with all the disclosure. Mr. Parvin has been getting all of the discovery. Everything has been sent to Mr. Parvin. All he has to do is he goes to the jail and then he has to play it.
Okay.
I know Mr. Parvin has not wanted to play, or sit there with him as much as he wants, but that's the requirement.
Ms. Stiles, what is so Judge Metcalf has a hearing Monday afternoon at 4 p.m. Is that correct?
So the judicial assistant has been scheduling that.
What is going to be heard at that date?
So there's one motion, it was the bond hearing, and then the other motion, they're looking at scheduling that. Mr. Parvin has filed on multiplicity and then one on the constitutionality of the statute. I'm not sure that those are going to be set because one of them, we're also within the reply time, but I think that may be.
I get 3 days reply, but your response is due on Monday.
I know when my responses are due, and it's actually 5 days, Mr. Parvin.
So
But-
I'll leave it at.
The judicial assistant's already working
Hold on.
it.
So with regards, hold on, please. Thank you. With regards to the motion to dismiss, can we calendar that today or can we schedule that?
So I don't know, is that the,
So there's
One
a
other.
motion to dismiss in 1454. I believe Mr. Myers is intending to join that in 1060. So can we set that motion to dismiss for hearing in both matters?
so the judicial assistant's already scheduling all of them. And
Okay.
so I just don't want to get on top of what she's already doing as far as the scheduling.
I think we're in open court, so let's try to do it right now. So with regards to the motion to dismiss, yes, I will, but, so it's been filed. Your response, we need, what, probably 20 days, is that about right?
No,
I would think,
No, 10.
plus a reply,
wait.
plus time, a couple days for the judge to read it,
Can I reply
okay?
about the law library thing for a second?
I-
She just said that I have access to the tablet to read the
Sir,
statute. Reading the
Myers,
statute doesn't help
can
me
I
prepare for a
want to
case.
stay
I
on
need
one
this-
thing at a time.
This is why I suggest on Monday, we do all calendaring that day
Okay.
at 4 o'clock. If
All
we
right.
have to, you know, I think
That's
that's
fine.
best.
All right.
Because there's too much going on today. And
It is ordered setting a hearing in both matters on Monday. At that time, the court will set any hearing. Court will, for now, set trial in 2025-1454 on July 21st. Court will set trial in that matter. It'll be a 5-day trial.
Be 2025-1060 is the first one being set.
So I understand, but here's my concern is with regard to Mr. Myers asking to have a hearing or asking to have his trial sooner.
I can't hear you.
Okay. I'm only going to set trial in the 1454. There's no motion to consolidate. Mr. Myers is asking to have a trial earlier on Monday. Judge Metcalf can swap out those two trials, but for today, Mr. Myers is objecting to that, wants a trial sooner. Given, I'd like to hear, I haven't heard kind of a timeline to see about what it would take for Mr. Myers to file those 3 motions, have the state respond, set up oral argument, and then trial. So we'll come back here Monday at 4 p.m. and court in 2025-1454 will set trial July 21st. If any party wishes to use a questionnaire, that they file a written request no later than 60 days before trial. With regards to that trial, it will be 5 days, 8 jurors, correct?
12.
Well, it's depend.
12-man jury, unanimous only.
It's
I'm facing more than 30 years.
So yes,
So-
so with the,
Is it,
so not, so,
if both are consolidated, it would be,
yes.
so it will be a 12-person jury, okay?
Unanimous.
That's by set, that's by constitution.
I know.
sir. Okay, of course.
I'd like to reply about the law library because she just lied in open court.
All right, Mr. Myers, here's what I'm going to do. Your hearing's on Monday. I'm not your judge.
All right, so talk to
Okay.
him about it.
Correct, sir.
Thank you.
And
All
I have a
right.
concern, Your Honor. Mr. Myers has already said that he wants me to litigate this motion to dismiss I filed, but he wants me off the case after that. So, and he doesn't want that trial date. So I don't think the court should set a jury trial date. I think we should wait till Monday because Mr. Myers is clearly objecting to that date as well and wants me off the case essentially.
All right, I've set a trial.
He
Then
said
at that
so right
point,
now you are setting it on the only mine. Okay.
that's correct. And then if that's the case, then Judge Metcalf can either set that in the 1060 or he can accelerate that to make sure that that trial can be heard soon. Okay?
I just
But
wanna make
only
sure-
under Rule 8, you
One
can only do
person.
that under extenuating circumstances.
You
We're
can enhance
within.
it. That's about continuing.
Okay.
Yes.
It's not being continued.
Yes.
I just want to make sure that Mr. Myers has joined in my motion to dismiss, so when I litigate that, it'll be both cases.
The court will note that in CR 2025-1060, that Mr. Myers has joined the motion to dismiss in CR 2025-1454. That motion was filed on April 11th, 2025.
And the other 2 motions I filed do not relate to Mr. Myers. Well, so therefore there's my motions. That's just the multiplicity. He doesn't need to join in those.
Okay, thank you.
Your Honor, at the last hearing, we discussed a settlement conference. I have tried to reach out to Mr. Parvin and talk to him about a settlement conference. Mr. Parvin has not been willing to engage in contacting the courts to get a settlement conference set. So I don't know where we're at with that because Mr. Myers is representing himself in one matter, but then Mr. Parvin. So I just want to be clear, is the state was willing to engage in that, but I can't do that if the defense
Can I respond
doesn't.
to that?
Sure.
I asked for a plea. If the state wants to offer even a prison-only plea, then I'll request a settlement conference and talk about it. But I'm not going to just do nothing and not file motions and do my job and, where I had time to write motions. I had a available week where I spent almost every day working on the motions. I had a lighter schedule and I got it done. I'm not going to wait to see what may or may not happen at a settlement conference. What the state tells me, there's not going to be a plea and we have to talk about a settlement conference. Send me a plea and then I'll request a settlement conference. But if you're not going to set a plea, I don't see the point of it. That's just what I'm saying, Your Honor.
Okay, Mr. Myers.
And then in my, that's on that 154 or whatever, right? And I'm saying on the 1060, if she's going to argue that I should stay in jail with no bond, there's no plea bargains.
Okay.
Thank you.
All right. At this time, I'm not going to order, I mean, again, it's not my case, but I'm not going to order, I wouldn't order any party who's not willing to participate in a settlement conference and I'm not going to order them to, because I think it's meaningless, so.
Yeah, I just wanted to make clear that we were willing to engage in it. If they're not willing
Okay.
to engage in it, then there's no point in us
All right,
doing
and
so.
Mr. Parvin
So-
saying-
We're willing. We want to make sure that
No,
we're willing,
yeah.
but she hasn't offered nothing.
We are
Yeah.
willing to engage, but we'd like a plea first, even if it's a plea we don't like.
And-
That would at least have a starting point.
And Your Honor, I've made clear that we would engage in the discussions
Okay.
for a plea at a settlement conference. So it's kind of going to the settlement conference is what would,
But
so if
then-
they want to engage in that, I'm happy to do so. If they
Sounds
don't
good.
want to, we don't need
Yeah,
to.
but the state asked me to hold off on filing motions until we had the settlement conference, and I can't do that because I had time to get them done when I did.
Absolutely.
And I got to file with my rule 12.9 and all that within a certain period, and it's going to delay the time and do all that kind of stuff. Well, she don't get her cake and eat it too. She don't get to hold me in jail with no bond and then dangle pleas that don't exist over my head and then get mad when we make a T-shirt with her face and say that there's not going to be no plea bargains because we made a T-shirt with her face on it. She don't control it. A plea bargain has to be signed by me.
That's correct, sir.
That's right. So she can take her plea bargain back to her office.
Okay.
Your Honor.
So hold on. We're just going to come back here. So the next hearing will be Monday before Judge Metcalf at 4 p.m. It'll be 1 hour,
Earlier, hopefully.
maybe earlier. But I'm not going to, that's not an order, okay? So the order will
Okay.
come from in chambers. It sounds like there's discussion to make sure that it works for both your counsel.
Yes.
Yes, Ms. Stiles.
Well, that was what I just
Okay.
wanted to make clear
Sounds
is at
good.
the time that they were still working on it.
All right. So the
Let
exact
the
time.
record reflect, if she wants to send me a plea, I see inmates get pleas every day.
Okay.
I haven't received one.
Okay. You're right. I see that all the time.
Yeah, I know.
You have a good day,
I
Ms.
see them
Miles.
open their mail every day. They got a plea bargain from the Pima County Attorney Office.
Okay.
What, we're gonna go? Why would we go to a settlement conference that would waste the court's time when I might not even want their? So if I had like he's saying the same, right? We're you know in agreement here, right? He's saying send us a plea, we'll talk about it. I'm saying send me a plea, we'll talk. She hasn't even sent me the witness list, let alone a plea bargain.
All right.
Can you,
Thank
and can you order her to produce the witness list by 5 p.m. today, please? She's in violation of Rule 15 right now by not providing the witness list. So can you order her to provide that by 5 p.m. today?
So just to be clear, with regards to the witness list, do you know?
So it says on the initial disclosure that we send, it always indicates that the people that are within the disclosure are
That's not the law.
are
Hold on,
witnesses.
Ms. Miles.
I'm happy to send him a more specific
Okay.
list.
Thank
He
you.
already knows who the people are. We've already discussed it.
Okay.
So
That's
a lie.
fine.
That's a lie.
With-
it's not.
Who's the witness?
Hold
Say it into
on.
the microphone.
I can tell you
Counsel.
right now.
Say it so I can go back
Monday?
and start working.
Detective Brown.
Monday, what time? So I'm asking, I just got a message from Judge Metcalf JA. She wants me to do an order. So with regards to the hearing on Monday, what works for both counsel? And I'll just pull up his
Earlier
schedule.
the better.
Earlier
because
the better.
I don't think 4 o'clock's enough time to get this done.
I would agree with you. Let me look, then what would be April 21st? He has 10:30 to noon.
April 21st,
Correct, sir.
that will not work for me. But again, I thought we were gonna
April-
do, I thought we were gonna do it on the 14th.
Oh, you,
About April 14th.
Today's
the
14th.
14th
Oh, no,
was
sorry.
yesterday. Yeah.
I'm thinking, oh, wait, the 21st, I thought we were doing in the afternoon because I already had a juvenile case scheduled that's also getting, I've been told that has to also be solved that day.
So can we
So there
do-
is something set from 4 to 5, but if you're asking for additional time, that's why I'm trying to find you something else.
Okay,
So-
no, I was told that we don't know how long that trial is going to go. They don't think it's going to take 3 hours, so we may be able to start earlier. So
Okay.
we can leave it at 4, but with the anticipation, we're going to start right after that other
Sounds
trial.
good.
We
I
can set it
will
for
let them
3
know.
o'clock, and then if they're running late,
All right.
we'll just be
It is
here.
ordered that it be, let me just look at one thing.
That is the only case I can't continue. Sorry. I gave you this. I know I need 3 copies. I got this one here? Oh, I got that.
That's our saying, can't send me a list of things and maybe a couple of copies. Well, I thought you were doing it.
I'm just looking, so he has a restitution hearing rested at 2 o'clock. I don't know how long it's going. I can't imagine it's an AG case, but an hour would seem to be realistic. So I can set this for 3 o'clock, but there may be some overlap.
Yes, and
Okay.
that's fine. I'm happy to wait.
Court will set a hearing in CR 2025-1454 as to the motion regarding bond. Additionally, the court will set a pretrial conference in both. Court will set a, in the 1454. Court will set a status conference regarding trial, and in the 2025-1060, the court will set a pretrial conference. So court will look to set trial in the 1060, discuss the trial date in the 1454, schedule any hearings on pending motions or motions that parties anticipate will be filed, and address the arguments regarding rehearing on bond. Yes, Mr. Myers.
See, and I'm trying to get back to this thing with the law library, because the jail sent me here with specific instructions today to come back with, because she's claiming that I have access to the tablet and if I want something printed and all this. And the jail said that's not true, okay? The jail said that he hasn't given any orders, and I got Specialist Zarate, badge number 7926. He says, the jail says there's no court orders in place for me to have access to the law library. And he said, if I want to have access, I must come back with a court order in my hand, signed by the judge, saying she's claiming I have access to all that. The jail would tell you they don't.
Okay, so let's set that on 10/6. Let's set
Well, I need to work on my case. So right now I've been in jail. I've had 368 hours available to work on my case, and I've been able to work on it 0, because reading the statute on the tablet doesn't prepare. I don't have the disclosure, and we have to go over hours of videos. And so how can Parvin sit there for hours at the jail when he's got other cases? So they're just trying to this is all a big tactical advantage game thing. They're trying to game.
Hold on, please. In CR 2025-1060, court will set a hearing with regards to defendants' access to legal resources at that time, okay? I'm not going to set it, yes.
Yeah, I just wanted to know, so is he saying that Mr. Parvin has not provided him his disclosure?
Don't say that.
I'm talking about you not providing my disclosure in this, what is the case number?
I've spent hours showing him
1060.
videos.
That's all right.
He wants copies 24/7.
That's not true.
Monday.
Can I fire him right now?
Thank you, Ms. Stiles, Mr. Parvin, Mr. Myers.
I can't have my lawyer lying in court.
Okay, fine, then I'm wrong. I'm sorry, I misspoke.
All right. I didn't even hear it. I'm looking at the dates, Mr. Myers.
Well, I mean, this is important. This is the only chance to make a record. She's claiming that I have access to disclosure. Then how do I go back? I want to go back to when I go back to the jail today. I want to work on my case. How can I pull out the disclosure and work on my case? Oh, you mean I got to have Parvin come down there when he has time? That's not effective pro se representation. And I'm supposed to go down to she said in the last court they were going to provide a laptop to go over this stuff. And furthermore, I am going to file a motion, and I need access to my jail calls so I can listen to them, where I'm going to catch them violating attorney-client privilege. And so how am I going to sit at the jail and listen to my jail calls?
Thank you, Mr. Myers. Mr. Myers, it's going to be heard on Monday, okay? Thank you, sir.
I just want one more thing, and I apologize. So what I meant is,
Counsel.
he wants copies of CDs, and he wants a laptop with him, because I can get a laptop. They'll give me one to show him anytime. But obviously once I leave, he no longer has access to it. I just want that was
correct.
Mr.
Yes,
Myers
that's what I'm
correct.
trying to say.
I apologize for misspeaking if I,
That's what I'm trying to say is, like, when he's not there, that's just, I'm sucking my thumb.
I get it. Thank you, Mr. Myers. Thank you, Mr. Parvin. Thank you, Ms. Stiles. Thank you. State of Arizona versus.
Is it all in the email what you need? I just want to make sure. Anything else?
State of Arizona versus. What is it? Urquidez. Oscar Urquidez, CR 2024-1148. Time set for initial appearance on a warrant. Parties announced.
John Robert Granger for the state.
Timio Scatteros for Mr. Urquidez. He's right here, Judge.
Morning, Mr. Urquidez. Mr. Urquidez failed to show to his sentence